All right, Ms. Phillips is coming up. Of course, she's not bound by the three minute rule. And while she's coming, let me just say I met last week with Ms. Peterson, Mr. Stevenson, and Mr. Spray. Had a real nice conversation with them, and I've met multiple times about this item with Ms. Phillips. And as I mentioned earlier, there's just lots to talk about with this item. So Ms. Phillips, whatever time you need this morning, why don't you give us an update on your perspective on things?
Thank you, Judge.
Right.
Thank you, Judge.
Right.
And Commissioners.
You can, if you'll hit that button.
There we go.
There we go, thanks.
Thank you, Judge and Commissioners, for allowing me the time today to speak on this most important issue. I'm here today with determination to further explain the resolution you received in your packet today, not only to the court, but also to explain in a clear and concise manner the concerned citizen will also be fully understanding of the gravity of this issue. The resolution before you today was adopted by the County and District Clerks Association of Texas in coordination with Jim Allison, legal counsel of the county judge, and Commissioners Association of Texas. The Texas Supreme Court, the State Office of Court Administration, and the software vendor, Tyler Technologies, signed an electronic filing agreement in order to create a standardized process for the state of Texas. The website efiletexas.gov was born with this agreement. For more than 5 years, through the number of boards, committees, and conferences, both statewide and regional, all county and district clerks were aware of the upcoming changes that eFile Texas website would bring. The creation of the eFile website, efiletexas.gov, meant that our offices would no longer have the customer at our counter filing in their documents, but the documents would arrive electronically. The county and district clerks were all in agreement to moving forward with this new technology, even though there were concerns about the amount of revenue which would be lost with the need to now print all electronically filed documents for the courts. As was mentioned, for over 5 years, the efiletexas.gov website was explained again and again to the clerks, allowing them the opportunity to ask Tyler Technologies any question to bring clarity to the process. The County and District Clerks Association of Texas also met with the Office of Court Administration and JCIT, Judicial Committee on Information Technologies, to address issues and concerns. When Tyler Technologies presented with every presentation, article, and breath, it was stated the documents would be purged from their system after 30 days. It was explained, maintaining the image for 30 days would provide access to the filer to the document for a period of that time. By providing a link to the document once the document was accepted by the clerk. A number of differing ways to file documents with the clerks across the state was as numerous as there were clerks. And again, the state was attempting to standardize and facilitate the filing process. The website, efiletexas.gov, was the answer to this issue. Along with the creation of the new electronic filing portal, efiletexas.gov, there were numerous orders directed to the clerks from the Supreme Court of Texas. One segment of the order, Rule 21C of the Texas Rule of Civil Procedures, entitled Privacy Protection for Filed Documents, clearly defined what sensitive data meant to the Supreme Court and how the clerk is to protect the documents containing sensitive data. I'll come back to that subject in a moment. The website, efiletexas.gov, is merely a delivery system of documents needed by the court from the filer. The delivery system is similar to those other delivery systems you may be familiar with, such as FedEx or the U.S. Postal System. These aforementioned businesses simply are a go-between to have your online purchases or your snail mail delivered to your home. Both the U.S. Postal Service and FedEx only deliver. They don't in any way hold your possessions for their own use. And that is the way the website, eFile Texas, was explained to the clerks. In November 2016, the County and District Clerks Association learned the documents filed through this website, eFile Texas, were being held with the county and district clerks' offices across the state without notice to the clerks, to the court, or to the judges. It's explained in the article in your packet, page 117, entitled Easy Access. The State Office of Court Administration is responsible for this mining of data. In the second paragraph, this article mentions, the Office of Court Administration conducted a recent poll asking if attorneys would use a statewide public record access system. And the result of the survey was found that 98% of the 3,000 Texas attorneys who responded stated they would use that system. There's just one glitch, many glitches I should say. The Office of Court Administration has no statutory authority to create such a system using court records without obtaining consent from the custodian of the records. With the mining of data from all documents electronically filed with the county clerk and county and district clerks across the state of Texas, a database was created named RE:/Search TX, referred to as Research Texas. We are learning more about the database called Research Texas, and this database is extremely troubling, to say the least, to the County and District Clerks Association of Texas. Research Texas is described as a convenience for judges, attorneys, and very soon the public, for document retrieval of documents electronically filed within the case. However, this convenience already existed with the creation of the website eFile Texas. Let me explain. When an attorney electronically filed a document, by statute, the only manner in which that document could be filed with the clerk is through the website efiletexas.gov. Once the document is filed, the clerk, the filer, and the opposing counsel receives a copy of that document. In the same fashion, when the opposing counsel files into the case through efiletexas.gov, the clerk, the attorney of record, and opposing counsel all receive a copy. Despite the increasing concerns of the County and District Clerks Association of Texas and Jim Allison, legal counsel of the County Judges and Commissioners Association of Texas, Research Texas is moving forward. A brief summary of the issues concerning the District and County Clerks of Texas are: 1. By the Texas Constitution and state laws, the clerks are the custodians of all court records. Statutes govern how the clerk is to protect and preserve the document in their possession, and how and when the public may have access to those documents. Even the amount the clerk may charge the public for copies is governed by law, statutes created by legislation. Number 2, the Supreme Court and State Office of Court Administration have no statutory authority to create a system for purpose of court records without the consent of the custodian and counties to whom those records belong. Number 3, Local Government Code Section 191.008 vests authority with the Commissioners Court to decide how and when and if documents are made available to the public for purchase via the internet. As late as 2007, an Attorney General opinion, Greg Abbott, GA-0566, the Attorney General confirmed the Commissioners Court have and retained that authority. Local Government Code Section 191.008 entitled Authority to Establish Computerized Electronic Information Systems states, the Commissioners Court the Commissioners Court may make records available through the computerized system only if the custodian of the record agrees in writing to allow the public access to those records. Number 4, the Office of Court Administration also publicizes their intent for the database Research Texas, as it is a convenience to the public. Statutes regulate how the clerk is to make the court records available to the public during regular business hours. Additionally, each county has a judicial website or the likes thereof where attorneys and the public may review cases and see what's been filed into the case. It provides attorney of record, name of defendant and plaintiff, cause number, court assignment, case style, and the nature of the suit. Number 5, the association takes the position that the decision of availability of records should follow the statutes written by legislation and strongly believes convenience is not a sufficient reason to take away or undermine the authority of the county elected officials, namely the Commissioners Court and the county and district clerks. 6, presently the Supreme Court nor the Office of Court Administration have provisions in place for redaction of confidential information contained in court records. You may recall the recent issue in my office to ensure our documents were available through the county clerk's public access terminals, the intranet, to avail those records to the public as allowable by law. Earlier, I mentioned the Texas Supreme Court order and their definition of sensitive data and the handling thereof. Under current rules, clerks are charged with responsibility to ensure sealed, confidential, and/or expunged records, and documents containing sensitive information must not be available to the internet pursuant to various statutes and the court orders. The clerks fulfill this duty by ensuring their paper case files and electronic files are secured.